Professor Alina MIRON, please kindly take the floor.
Good morning, everybody. Thank you, Judge Cassaone. First of all, I would like to thank the organizers, the Ministry of Foreign Affairs of Korea, ITLOS, and the Korean Society of International Law for their hospitality and the generosity. As I told my colleagues yesterday, the bar now is very high set out for the next conferences, so I think it's a challenge for us. We'll have to organize in the future some conferences. Well, you will see that even if we do not coordinate, despite the attempts of the organizers to have us coordinating among ourselves, actually we may speak about the continental shelf beyond 200 nautical miles for quite a while. The focus of my presentation is the contribution of ITLOS to the cases, to the maritime, to the law of maritime delimitation. And we heard yesterday President Hoffman and Judge Paik, to some extent, talking about the need of having a system and what is required to have a system in international law. And as President Hoffman said yesterday, when the convention and Part 15 was established, the plurality of judicial fora created indeed concern about the fragmentation of substantive law, but also to some extent concern about the possible competition among the various tribunals set out in Part 15, which could have been tempted to assert an expansive view of their jurisdiction just in order to attract clients, if I may say so. And the fact that the states may choose the tribunal under Article 287 of the Convention at any time could have indeed contributed to that competition between international courts and tribunals and could have created a risk of forum shopping. Now, I think it is really fair to say that the fears of fragmentation have been largely overcome nowadays. And also, I think the fears of competition, although to some systems, competition is sometimes considered to be a good thing, a wealthy thing. But on the substance, I think all the commentators now underline the convergence and the unity of international law, in particular the unity and harmonization, at least, at the interpretation and application of the Convention. So I think fragmentation is indeed dead. Long live harmonization of an uniform interpretation. And how this uniform interpretation managed to build over time? Well, it's quite easy. It is by a systematically reference, or even, I may say sometimes, deference to the decisions adopted priorly by other courts and tribunals. For instance, ITLOS referring to the ICJ, and we have seen lately the ICJ referring to ITLOS. And this is not done out of courtesy of the judges, it is done out of a sense of necessity. And it is the sense of necessity, I think, that transpires when we are reading in Bangladesh, Myanmar, that there is, in terms concerning maritime delimitation in particular, there is this need of transparency and predictability of the delimitation process. And indeed, this need of transparency and predictability is the main reason that we have nowadays a common method of maritime delimitation. And I think I like the concept of acquis judiciaire. I think it translates quite well this gradual building of an uniform law through the reiteration and cross-references to existing decisions. The expression, the phrase acquis judiciaire was invented by, if I may say so, I think by Judge Wolfram in his declaration in Bangladesh, Myanmar. And it, of course, refers to the acquis communautaire for those who have studied European Union law. The acquis communautaire, indeed, is gives the feeling of the existence of a single system. And the phrase resurfaced, and that's no coincidence, in Bangladesh versus India, in the judgment itself, in which the acquis judiciaire was defined as being the ensuing and still developing international case law. And this international case law constitutes, in the view of the tribunal, an acquis judiciaire, a source of international law under Article 38(1)(d) of the Statute of the International Court of Justice, and therefore should be read into Articles 74 and 83 of the Convention. Therefore, actually, what the acquis judiciaire manages to do is to incorporate the case law on maritime delimitation into the Articles 74 and 83 of the Convention. Professor Magnusson gave some of the examples of how the acquis judiciaire built into maritime delimitation and gave us the tasks of filling in the gaps of his presentation. Well, I think it's, there are the acquis judiciaire, it's a dynamic concept. It's not done once and forever. And indeed, I think there are some points, including concerning the law on maritime delimitation and the standard method, the three-stage standard method. There are some points on which the law can still be clarified and on which some acquis judiciaire is still required. The points I am thinking about in particular concerning the three-stage method of delimitation is, for instance, the choice of base points. The choice of base points is first of all a technical question, because the base points are chosen in order to determine the provisional equidistance line on the basis of the digitalization of charts. And of course, the choice of base points is first of all a question of the choice of charts and the appropriateness of charts. So we have quite very few information on how this is done, and but we do have some information that sometimes this raises some risks of errors, and we have seen, for instance, the ICJ in Somalia, Kenya, correcting the technical aspects on the choice of base points. The one that it had declared, it had published first. The choice of base points is also a question of subjectivity, because there is a choice indeed. It's not an automatic choice done by a computer program on the basis of the digitalization of the charts. There is to some extent, some subjectivity in the choice by the international courts and tribunals, and there is little to say, if any, guidance on how this choice, what are the elements for the choice of these base points. Concerning the determination of relevant coasts and irrelevant areas, here again, there is little information on how it is done, and there is so much little information that the lawyers themselves play around on how they would best portray the relevant coast and relevant area for their case. Concerning the relevant circumstances. Now, the relevant circumstances, there has been quite a lot of harmonization in the case law. The harmonization tended towards expressing the fact that the relevant circumstances are first and foremost the circumstances of a geographical nature. However, there is room for if not subjectivity, at least flexibility in the choice of relevant circumstances, because there is no exhaustive list of relevant circumstances. Therefore, there is room for adaptation to the circumstances of the case. But if there is something we really don't know about, is how the adjustment of the provisional equidistance line is done according to the relevant circumstances as identified by the international courts and tribunals. About this, we know so much nothing that I think it's pretty much a very artistic exercise, the adjustment of the equidistance line. But actually, I do not want to speak about this. What I want to speak are the two issues that were raised in Bangladesh, Myanmar, and Ghana, Cote d'Ivoire, that have been to some extent, that have developed to some extent into an acquis judiciaire, but it's quite an uncomfortable acquis judiciaire because we are not very sure about what we are talking about, actually. There are two issues. The question of the entitlement to the continental shelf beyond 200 nautical miles. The second issue is the question of the obligations of states in the disputed maritime areas. So let me spend some time on the entitlement to a continental shelf beyond 200 nautical miles. Before I do that, I do think that it is needed to get back on some of the definitions of the basic concepts I'm going to use. First of all, the entitlement. The entitlement, this is a subjective definition because I didn't find any in the existing case law, but we subjectively may consider that the entitlement translates like a potential right that the coastal state has to extend its sovereign jurisdiction over the maritime areas of its coast by the application of the relevant rules of the law of the sea. So it is about a potential right given by the adoption of the convention. Second, the claims. Well, the claims to the continental shelf, but not only, are the subjective positions by which a state asserts its own understanding of the extent of its entitlement. So you don't have necessarily the same view of an entitlement taken under the objective application of the law, and the objective application of the law would be done by the courts and tribunals, and the claims, which are actually the subjective views of the parties concerning their entitlements. And that's why sometimes we'll have quite a difference between the area of overlapping entitlements and which is used in the case law, and the area of overlapping claims. Third, the right to maritime areas. This is, the right is when you have the entitlement which actually translated into a title which may be opposable, if not erga omnes, at least to the neighbors who have challenged that entitlement. And most of the time, a title to the maritime areas, therefore a right which is certain, will derive either from an agreement on delimitation or from a decision of a competent tribunal on delimitation. So the delimitation will be there when there is a challenge to the entitlements. The delimitation will bring the certainty of what is the exact extent of the rights of a coastal state. And now the distinction between delimitation and delineation, to which Professor Magnusson referred. The delimitation is the process of resolving the overlapping claims, or sometimes entitlements. We found that both in the case law, by drawing a line of separation, a boundary line between the maritime areas concerned. And the delineation, as we all know, is the establishment of the outer limit of the continental shelf margin. That's pretty much the elements of definition I wanted to put forward first. Now, how a claim or an entitlement may actually translate into a right. And this is where I'm going back to the question of the importance of maritime delimitation. In Ghana, Cote d'Ivoire, the Chamber of ITLOS made a statement which seemed quite bold to some extent to some of the commentators. The statement was that in a case of overlap, both states concerned have an entitlement to the relevant continental shelf on the basis of their relevant coasts. Very well. Only a decision on delimitation establishes which part of the continental shelf under dispute appertains to which of the claiming states. This means that the relevant judgment gives one entitlement priority over the other. Such a decision accordingly has a constitutive nature and cannot be qualified as merely declaratory. This to insist on this could be discussed. It could be discussed because we have been taught that the rights, at least to the continental shelf, are inherent to the sovereignty over the land, and we do not know exactly what inherence therefore means if the delimitation comes in establishing the extent of the rights of the states to the continental shelf. But I think this part of the judgment does indeed reflect the importance of the Convention in granting to states entitlements to maritime areas and in accepting the fact that they have to decide on the maritime delimitation with their neighbor together if they have a problem of overlapping claims or entitlements. Now, the overlapping entitlements to the continental shelf beyond 200 nautical miles were established when we had overlapping entitlements and the question of delimitation of the maritime boundary. In Bangladesh, Myanmar, in Bangladesh, India, but also in Somalia versus Kenya. Most of the time, the question was quite easy to resolve because we have states with adjacent coasts and their continental shelf was in fact common. So therefore, the establishment of the entitlement was not so much an issue concerning the continental shelf. It was not an issue, well, it was to some extent an issue, but easily resolved in Bangladesh, Myanmar. It was not so much an issue in Somalia versus Kenya, for instance, where both parties recognized the existence of the entitlement of each other. But the entitlement to a continental shelf may, and it is indeed a problem, and it may interfere with the question of the delimitation when we are in the case of states having opposing coasts. This is, because it may happen that these opposing coasts do not necessarily have an entitlement to a common continental shelf, or it may happen that, like in Nicaragua versus Colombia, it may happen that one of the states actually makes a claim to a continental shelf beyond 200 nautical miles within the area situated within 200 nautical miles of the opposing state's coast. And the situation was described to be similar in Mauritius-Maldives case, although we saw in the latest hearings that the description made by the Chamber of ITLOS has to some extent developed during the merits. So in these situations, the question of the entitlement may indeed have a consequence in terms of maritime delimitation. And the question will be, how can this be resolved? And what I want to do now is to address some of the questions of the entitlement to a continental shelf beyond 200 nautical miles, which the ICJ is now addressing, and I would like to see how the ITLOS decisions may in fact contribute to clarify to the questions raised in Nicaragua, Colombia by the ICJ. Many of you may know that in the Nicaragua versus Colombia case, the second one concerning the delimitation of the continental shelf between the two states, the ICJ adopted an order on 4 October 2022 asking the parties to deal as a preliminary matter with the question of applicable law. So the hearings that will take place in December will deal with the questions put by the ICJ in this order of 4 October 2022. And I'm just addressing the first of the questions. And I put the text of the question both in English and in French because for those of you who are French speaking, you will see that we do not necessarily understand the question the same way if you are reading it in English and in French. In English, I'll just read it in English. The ICJ asked if under customary international law, may a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured extend within 200 nautical miles from the baselines of another state. So, and in French, actually, the word entitlement has been was translated, I don't know actually what's the original, but the French equivalent is the right, le droit. But the problem is, if we are going back to my definitions, is that in French you do not have a perfect equivalent to the word entitlement, and actually in some of the orders of the ICJ and in some of the opinions of the judges, it is translated as a right. But there is a difference between the entitlement, because the entitlement is a potential right. It is the potential right given by the convention to the states, whereas the right as such, it is the one, the extent of which has already been established through delimitation. And you will see that this confusion, at least in French, between right and entitlement, and I'm wondering if it's really a confusion just of translation, if we are just lost in translation, or if we are lost in the concepts themselves. And I think this order of the ICJ, and I'm also referring to the declaration by Judge Abraham, actually shows that there is a confusion not only of wording, but also to some extent of the concepts themselves. So the court framed this as a question of customary international law. This would mean that there is, under customary international law, something more than what we have already in Article 76. I suspect the court, the court was inspired by some of the discussions in the doctrine, which tried to establish on the basis of the practice before the CLCS, if there is a way to interpret Article 76 of the Convention, which would actually exclude any kind of entitlement to a continental shelf beyond 200 nautical miles, when this entitlement will actually step into the entitlement based on distance, the 200 nautical miles entitlement based on distance. And I'm putting on the screen some sentences of a book published last year by Professor Liao, The Continental Shelf Delimitation Beyond 200 Nautical Miles, where she's actually analyzing in a very exhaustive manner the practice of state before the CLCS. And in her book, indeed, she's concluding that states which which made submissions to the CLCS, when they have an opposing state which has an entitlement to 200 nautical miles, are actually refraining from asserting their entitlement up to the 200 nautical mile limit of their neighbor. However, this practice, even if this is an important majority of states having this practice, it's not uniform. And Professor Liao, she counted at least 6 individual submissions which depart from this body of practice of self-restraint when there is another state having a 200 nautical miles entitlement. And among them, China, Korea, Nicaragua, but also France in respect to Saint-Pierre and Miquelon, Vietnam, and Malaysia, who are having this claim to a continental shelf beyond, which encroaches upon the 200 nautical miles entitlement. So actually, and getting back to the question of the ICJ, which is a question of entitlement, having a potential right to a continental shelf. When I'm reading the question both in English and in French, I'm really wondering if this is about entitlement or if it is about delimitation. Because the question of entitlement, it's one which is put in an objective manner. A state either has an entitlement or it has not. If it's a question of delimitation, it is about separating existing entitlements. However, as you see, in English, the question was drafted as a question of entitlement, not as a question of delimitation. If this is a question indeed of entitlement, for me, it creates quite a difference with the existing case law. I don't know if it really aligns with the existing case law. If it's a question of entitlement, then I think the positive answer is quite certain. And we can refer to already existing case law. In Bangladesh, Myanmar, the concept of a single continental shelf was put forward by the tribunal. And that single continental shelf asserts the unicity, the unity of the continental shelf within and beyond 200 nautical miles. If we are having a question of entitlement, when you have a neighboring state which has a 200 nautical miles entitlement, then how does this compose with the principle of the single continental shelf? Is it about establishing a hierarchy of entitlements, the geomorphological entitlement on the one hand and the distance entitlement on the other? I'm a little bit confused from this point of view. How does this combine with the single continental shelf? There is also the acceptance of the gray areas. The gray areas were defined by ITLOS in Bangladesh, Myanmar, as an area which is situated beyond 200 nautical miles from one state, Bangladesh, but within 200 nautical miles of Myanmar. And therefore, why it is a gray area? Because we will have a continental shelf beyond, as far as the seabed is concerned, and an EZ, therefore a distance entitlement in the water columns. The existence of the gray areas and the acceptance of the gray areas, including in Somalia versus Kenya, actually shows that there is no priority concerning the geomorphological entitlement and the EZ entitlement, and also it shows that we can have an overlap of entitlements. And last but not least, and maybe I should have started with that, the criteria for entitlement. The criteria for entitlement as established in Article 76 of the Convention, well, there are, and as developed by the case law, we have two cumulative criteria. First, the land dominates the sea. Therefore, and as it has been expressed in North Sea continental shelf, the land dominates the sea through the projection of the coasts or the coastal front. Very well, so this is a sine qua non criteria. And to this sine qua non criteria, sovereignty over the coastal areas, we may have two alternative criteria which were defined in our Article 76, either the distance criterion or the geomorphological criterion, which would be applied in a successive manner. Therefore, we have two criteria, and these two criteria are applicable without any kind of hierarchy. At the moment when these two criteria, the land dominates the sea and the distance or geomorphological criteria are established, it means that the entitlement exists. I don't think we can interpret the land dominates the sea as meaning the land of your neighbor is dominating your maritime areas, because putting the question of the possibility of having overlapping entitlements as in Nicaragua, Colombia, it will mean that actually the distance from the coast of your neighbor would actually become part of the appreciation of the criteria for entitlement. And I don't think we can read that in Article 76 of the Convention. So in the end, I don't think it's a question of entitlement, the potential right to a maritime area. I think it is a question of priority of entitlements, but a priority of entitlements as the ITLOS put it in Bangladesh, Myanmar, it's a question of delimitation. The definition given by ITLOS for delimitation was to establish the priority of entitlements. And we see that it is a question of delimitation and not of entitlements in Judge Abraham's declaration, in particular in Article 7, when he presents the position of Colombia and he translates the position of Colombia in his own terms. According to Colombia, the entitlement of a coastal state to a continental shelf within its own 200 nautical miles always and necessarily prevails over another state's entitlement to an extended continental shelf beyond its own 200 nautical miles. It therefore follows that even if Nicaragua could establish that its continental shelf does extend beyond 200 nautical miles, this is the entitlement. The applicant's rights arising therefore could only be exercised to the limit of Colombia's exclusive economic zone. Now, I'm not sure it's a question of exercise of rights, because the exercise of rights is when you have actually a right. So we went from entitlement right plus exercise of rights. And as I said, delimitation is about establishing which entitlement has priority. But again, the declaration of Judge Abraham is interesting on another point. When you're looking down to the issue, what is really this about? Is this a great question of, a theoretical question of entitlement, or is this a very prosaic question of how dealing with the technical aspects of establishing entitlement to a continental shelf beyond 200 nautical miles? And I think the Judge Abraham makes it quite clear that this is about engagement with technical issues by the ICJ. It will be determined whether there is a case for delimitation, and therefore whether or not there is a point in determining, with the assistance of experts or otherwise, the extent of the continental shelf. A wise judge does not enter into convoluted, lengthy, and coastal arrangement for an expert opinion without first ascertaining whether it is worthwhile. So it is about establishing, bringing the evidence of the existence of a continental shelf beyond 200 nautical miles. And of course, we know that this evidence relies on geomorphological criteria. Until now, the tribunals refrained from engaging with this very complicated technical issue, let's be honest. They refrained because most of the times the parties agreed that there was an entitlement, or they also refrained from actually engaging with these issues because there was a CLCS recommendation for Ghana, and that was quite easy. In Somalia versus Kenya, the parties agreed, and there were already submissions to the CLCS. But what about the situations where the parties do not agree that the other one has an entitlement, where the subjective views of the parties makes it necessary for the tribunals to engage with these technical issues? And I think this, in the end, raises the question of having expert opinions, not only from the parties, but from outside. And indeed, this may cost money, and it may be necessary to determine how these financial issues can be resolved. Maybe, probably with the participation of the parties, why not? But what we cannot do is to avoid the question forever. There will be moments when the questions must be decided, and I think in the end, Nicaragua, Colombia shows that we are in that situation. So that was pretty much what I wanted to say about the entitlement to the continental shelf beyond 200 nautical miles. Very quickly about another topic, the one of the obligations and the disputed maritime areas. And Ghana, Cote d'Ivoire may seem to be a missed opportunity to develop the law, but I think not that much. It was indeed a missed opportunity, and I think Judge Paik expressed it quite clearly in his opinion, separate opinion in Ghana, Cote d'Ivoire. But there were issues decided by the Chamber of ITLOS, which became actually an acquis judiciaire, whether we like it or not. And for instance, the question of the violation of sovereign rights in the disputed maritime areas. As a matter of definition, a disputed maritime area is an area of overlapping claims, not of overlapping entitlements. The disputed maritime area is defined by the claims of the parties, the subjective claims of the parties, and we may hope that those claims were made in good faith. And in Ghana, Cote d'Ivoire made the point that if Ghana was exploiting the maritime area, which should pertain to it in the end, there would be a question of violation of its sovereign rights over the continental shelf, which were supposed to be inherent and exist from the very beginning. The tribunal, the chamber of the tribunal could have said, well, actually, I don't have to answer to that question because none of the area exploited by Ghana was ultimately awarded to Côte d'Ivoire. So the chamber did not actually have to engage with that question, but it did as a matter of law, and as a matter of law, the chamber established that when maritime claims of states overlap, maritime activities undertaken by a state in an area which is subsequently attributed to another state by a judgment cannot be considered to be in violation of the sovereign rights of the latter if those activities were carried out before the judgment was delivered and if the area concerned was the subject of claims made in good faith by both states. Therefore, when the activities, at least for continental shelf hydrocarbon activities, were taking place in a disputed maritime area and the claims were made in good faith, that cannot give rise to responsibility. And I think the chamber was preoccupied to extinguish the disputes of the parties and not to create a source of disputes in international law, because we know that there are quite a number of disputed maritime areas which are currently under not exploration but exploitation by one of the states without having a maritime delimitation. And that solution from Ghana, Côte d'Ivoire was reaffirmed by the ICJ in Somalia versus Kenya. So I think it more or less cut the ground of the argument of responsibility for violation of sovereign rights with the limitation of the good faith claims. That may be a possibility. The other question concerning responsibility concerns actually the interpretation of paragraph 3, common of Articles 74 and 83, and in particular of the obligation not to jeopardize or hamper the reaching of the final agreement on delimitation. From this point of view, the Ghana-Côte d'Ivoire decision gave some but very light ideas on how to interpret. The very light ideas because the chamber decided to talk a lot about good faith in negotiations in particular, but did not engage with the question of what is the obligation of restraint in a disputed maritime area. Well, if this is a missed opportunity, I think it's to some extent the fault of the team of Côte d'Ivoire, and I was a part of, which framed the claims in an improper manner. It tried to apply the obligation of restraint not to the whole of the disputed maritime area, but only to the part which would be awarded in the end to Côte d'Ivoire. And too bad for Côte d'Ivoire, the chamber decided to take upon this bad framing of the claims by Côte d'Ivoire to say that it does not have to decide of what is the obligation of restraint. And this is how the ICJ turned back to this question in Somalia versus Kenya, and it gave a little bit of confirmation of what we knew from what we knew from Guyana versus Suriname. In Guyana versus Suriname, the arbitral tribunal decided that the activities which would constitute per se a violation of the obligation of restraint are in fact the activities which lead to a permanent physical change in the marine environment, and therefore in particular the drilling activities, but not exclusively. And the ICJ decided that that was indeed a proper standard as far as hydrocarbon activities were concerned. But this is pretty much what we have on the standard of restraint for the moment. And I think the types of activities in disputed maritime areas do not only concern drilling for oil and gas. There are some other types of activities, including military activities. So I think it is important, and police enforcement activities. And I do think it's important to have some guidance on this because there is much at stake behind it. And I'm just referring back to what Judge Paik was saying in his opinion in Ghana, Côte d'Ivoire. So that's pretty much it for my presentation. Thank you very much.
Professor Miron, thank you very much for your statement.